From New Jersey for those very cogent remarks. And now I'm pleased to recognize the gentlelady from Texas, Ms. Jackson Lee.
Let me thank the gentleman from New Jersey for his very careful scrutiny of Judge Gorsuch and for participating with us tonight. And it gives me great privilege to join with the distinguished Congresswoman from the District of Columbia to be able to really articulate what is at stake with a potential for Judge Gorsuch to become, Justice Gorsuch, to become the 9th member of the United States Supreme Court. As I do that, allow me to offer a personal note of sympathy to my hometown, to the constable's office in the shooting and death of Chief Clinton Greenwood, to his family for this tragic death, and to acknowledge his service that he has given in many, many ways as a law enforcement officer and attorney committed to the implementation of the law. Our sympathy goes to his family and to his colleagues. I also want to acknowledge the tragedy in Russia and the loss of life, which indicates how close all of us are around the world, and that we should be committed to the fight against terrorism wherever it may be. I think that leads me to my appreciation, and if I might applaud the senators, the Democratic senators in this instance, in the other body, to express my appreciation for taking a fight that many would be critical of. Now, that fight I don't put in the context of politics or partisanship. I've not heard one senator, at least I've not heard them, who is opposing Judge Gorsuch and is not supporting or participating in the filibuster, mention one word about the political elections or the process that occurred in 2016. I've heard truly deliberative analysis that I think is important to recount. Congresswoman Norton, and I'm delighted with your expertise and the distinguished leadership that you give us as our chair of the Judicial Nominating Committee for the Congressional Black Caucus, a position that you have served ably for years and has resulted in some outstanding jurists because of your leadership that the Congressional Black Caucus has been able to advocate for. During the tenure of President Barack Obama, as you worked very closely on his nominees, distinguished jurists have been placed on the federal bench and on the Supreme Court, to no one's complaint. In addition, President Obama followed protocol and consulted with members of the other party in the United States Senate. Unfortunately, we start this process now, or we're now ending this process of the nomination of Judge Gorsuch by the President of the United States, this President, who announced it as a campaign trick by issuing a list of individuals that he had not vetted, but had been given by those who were bartering. This is a list, and you'll have our support in the election. My fear is that that is not the context in which distinguished jurists should be appointed to the Supreme Court. There is no doubt that this was bait for voters to be able to fall in the column of this particular individual who now holds the office. So, no criticism should go to my colleagues in the other body who realize that this is about life or death matters. This is about the millions of Americans that will suffer at the hands of Judge Gorsuch on the United States Supreme Court. I am more convinced now, and I am grateful for their debate, because as they have debated in a very detailed, passionate manner, I hope that they've been able to provide light and education to Americans who may be watching and trying to understand the no vote and the yes vote, the filibuster, that it is not in any way anyone's political desire to not have the Supreme Court working on behalf of the American people, adhering to the high calling and ultimate judgment of the Supreme Court, which is to recognize settled law and to be able to respect the rights of all Americans and not skew this court to the point that some Americans will be left out in the Hall of Justice. Why should my friends in the other body who have taken this courageous stand yield to false criticism and pontificating and grandstanding about they've never seen this before, the other persons who voted yes, they've never seen this before, this is outrageous, a qualified individual? I have no angst against the person. He has ascended to the 10th Circuit. He has colleagues who respect him. He showed himself respectful before the Senate Judiciary Committee. In fact, some called him charming and engaging. But again, I make mention of the fact this is about life and death. So let me put in the context a very important statement made by Amanda Bronsted, the National Law Journal, February 28, 2017. Neil Gorsuch's piercingly textual and often pro-defense on class actions and arbitration. According to a careful review, this is quoting from that article, of Gorsuch's decisions, his textualist approach, more than ideology, is a common theme of his opinions on class actions, arbitration, and mass torts, leaving out eons of people to find justice. And yet, though some of his decisions have favored plaintiffs, Gorsuch's careful judicial reasoning and parsing of statutory language has more often led him to side with the defense, leaving most others out in the cold. In addition, Judge Gorsuch has a disdain for those who seek to redress their civil rights and other violations of law. In a 2005 article published in the Conservative National Review, these are his words: American liberals have been addicted to the courtroom, relying on judges and lawyers rather than elected leaders in the ballot box as the primary means of affecting their social agenda. On everything from gay marriage to assisted suicide to the use of vouchers for private school education, this overwhelming or overweening addiction to the courtroom as a place to debate such social policy is bad for the country and bad for the judiciary. Well, Judge Gorsuch, let me tell you a thing or two. I grew up in a segregated America. At my birth, African Americans were treated unequally in terms of education, as well as accommodations, as well as the right to vote. And we couldn't even march in some places in the Deep South without being shot at, losing our lives, being hosed at, and dogs making sure that our young kids were intimidated and even bitten. Maybe he fails to remember the 4 little girls in the church in Birmingham, called the bombing in Birmingham in 1965. Maybe he fails to remember the tragedy of the Edmund Pettus Bridge, or Jimmy Lee Jackson shot dead in the streets of Selma. Or maybe he doesn't understand Brown versus Board of Education, Roe v. Wade, Miranda versus Arizona, Gideon versus Wainwright, New York Times versus Sullivan, Oberfeld versus Hodges, and Shelby County versus Holder. These cases dealing with issues such as the right to vote, the right to an equal education, the Fourth Amendment interpretation, the right to be protected from unreasonable search and seizure, the First Amendment right to freedom of the press. Maybe he doesn't understand that these cases have brought to America the image and the recognition of justice. It doesn't seem that he has that interpretation. So I just want to read another interpretation of his record by the Leadership Conference on Civil and Human Rights. Judge Gorsuch's decade-long record on the federal bench, as well as his writings, speeches, and activities throughout his career, demonstrate he is a judge with an agenda. What a frightening proposition, that he goes to the Supreme Court having given the impression that he is just an open book, genuinely concerned. His frequent dissents and concurrences show he is out of the mainstream of legal thought and unwilling to accept the constructs of being a binding precedent and stare decisis. When they dictate results he disfavors. Stare decisis is something that we learn in law school, that is a very appropriate and important basis of decisions. If confirmed to the Supreme Court, which is closely divided on many critical issues, Judge Gorsuch would tip the balance in a direction that would undermine many of our core rights and legal protections. He lacks the impartiality and independence the American people expect and deserve on the federal bench. Let me make one or two other points that I think is so very important. And I hope to put my entire statement into the record, and we'll be engaging. I know that my colleague will have further comments, but I want to make sure that we point back to those who are criticizing a very courageous stance, because they're taking the stance, my friends on the other body, in the backdrop of all these accolades and how genuine and charming he is. I said that before. But he is going against the backdrop of protocol, no engagement with the Democratic senators, no adherence to the president when he was president-elect, who pledged to the nation that he would be the president of all Americans, because it rings hollow to tens of millions of Americans. My colleague from New Jersey mentioned the truck driver story. It was a 2-to-1 decision. He was dissenting. No person with common sense and knowledge of the law will reject the understanding that this individual acted not against the instructions of his employer in leaving a truck that, by the way, the cargo area of the truck, nothing was violated, no product was taken, and this was bad brakes, and in jeopardy of his life, if he had left the cargo portion of the truck and tried to drive away on this frozen night after waiting 3 hours in a cabin where he's freezing to death, he would have died. And yet Judge Gorsuch did not think that was important enough to rule in favor of this African American who had a 2-1 decision. He thought that the employer could fire him, and there was no factual basis for that he did something when it was a balmy day and he just went off recklessly because he didn't want to be bothered, or he was tired, or he was hungry. That was not the case. That is cruel, Judge Gorsuch. Your conservative ideology and professed judicial philosophy of original intent has harmed many. And he is not an unbiased judge. At best, he is a younger, more charming version of Judge Robert Bork, who was rejected 58-42 by the Senate in 1987. And so he has a history of ruling against people who have used the legal system to hold government officials accountable. The gentleman who was fired I think 7 years ago, and has not been able to find a job yet. By the way, the truck heater didn't work. His words were, Judge Gorsuch dissented and said the employee should have followed orders even at the risk of serious injury. In NLB versus Community Health Services, Judge Gorsuch again dissented from a majority opinion that found in favor of employees where a hospital was required to award back pay to 13 employees whose hours had been reduced in violation of the National Labor Relations Act. As a ranking member on the Criminal Justice Committee, we are trying to find the right kind of balance between police and community. But Judge Gorsuch has ruled that there is no reason to give police any punishment, such as the case when an individual used a stun gun and the victim died. Judge Gorsuch's judicial record on police accountability minimized the Fourth Amendment protections against warrantless search and seizure. So I will continue my discussions of Judge Gorsuch. I will, in a moment, after yielding to the gentlelady, come back again and finish my comments on issues dealing with, again, civil rights and the rights of women. I'm delighted to co-host and co-manage this hour dealing with the nomination of Judge Gorsuch. I yield to the gentlelady.
Well, I thank my friend for her comments. Mr. Speaker, I was a chair before I came to Congress in another life of the Equal Employment Opportunity Commission, dealing with job discrimination in our country. And I was interested in my own research to find out that Judge Gorsuch has written more discrimination cases than other cases. Now, the Rocky Mountain states of the 10th Circuit do not have large numbers of African Americans, but the way in which the Supreme Court has interpreted anti-discrimination laws doesn't, in fact, differ from race, from sex. The EOC also has jurisdiction over disability discrimination. The court has always indicated that these laws should be read broadly in order to capture discrimination. Whether we're talking about the anti-discrimination laws as they affect women or racial or ethnic minorities or religious minorities, the Supreme Court simply will not read these laws narrowly. But that is not how Judge Gorsuch has operated on the 10th Circuit. He has given cramped interpretation of the anti-discrimination laws. And yet it's interesting to note that when there is a claim of discrimination based on religion, he gives a very broad interpretation. He is perhaps best known for his opinion in the so-called Hobby Lobby case. This is a case in which he found that a closely held corporation was within its rights when it refused to adopt the Affordable Health Care Act's mandate that women and men be granted contraceptive protection. Judge Gorsuch found that that was a violation of the rights of the closely held corporation, the first time there's been such a holding. it's very interesting to note that right after that, there was a case called Little Sisters of the Poor. Now, the Little Sisters of the Poor, unlike the closely held corporation, is in fact a religious organization. And they too said they do not wish to have contraception to be a part of any of the institutions that they govern. Now, it's interesting to note that and remember, we have a religious organization there, not a closely held corporation. The court found that to accommodate both women and the religious scruples of the Little Sisters had to only acknowledge that they did not desire to enforce the contraceptive mandate, and then it would be taken away from them and would be done by a third party, by the government. That was allowed as a way to accommodate the Little Sisters. Judge Gorsuch opposed that and wrote an opposing opinion. So to see this difference in the way he treats discrimination, reading anti-discrimination statutes affecting minorities of every kind in a cramped fashion, when he finds religious discrimination by statute, he reads those statutes very broadly. His technical rulings are very disturbing of statutes that the Supreme Court has broadly interpreted, or else those statutes would have been worthless. You simply cannot enforce anti-discrimination statutes by treating them as though they were technical statutes that, for example, govern financial dealings. And yet, this nominee has brought that kind of interpretation to anti-discrimination statutes in the 10th Circuit. I was shocked at his holding in Hwang versus Kansas City University, which illustrates what I am speaking of. There, a professor brought a case because her university had refused to follow the guidance of the Equal Employment Opportunity Commission. It is true that she was entitled to a 6-month leave to accommodate her. This is a statute involving disability rights. She took that 6-month leave and asked to have it extended until a day certain, not indefinitely, following a diagnosis of cancer and bone marrow transplant. Now, the EOC guidance said that an additional leave beyond 6 months was possible as an alternative accommodation to an employee unless there was an undue hardship. There was no undue hardship. But this nominee, Judge Gorsuch, found that the 6 months was more than enough to comply with the law in nearly every case. Yes, in nearly every case. But the EOC guidance said that there obviously could be exceptions. And I can think of no case that would call for more of an exception than a professor who said, I will come back on a date certain, but I have a cancer diagnosis and I've just had or have had a bone marrow transplant. I hope that that kind of a holding would give some pause to anyone who hears about it. The nominee has been quite consistent in how he has ruled in the 10th Circuit, which gives every reason to believe that he is going to carry that consistency to the Supreme Court. I was very interested to see how he ruled on a Planned Parenthood case where the governor of Utah had seen these notorious false videos that purported to show the sale of fetal tissue. Now, those videos, every court that has considered those videos have found that they had nothing to do with Planned Parenthood and what it actually did. So this matter has been litigated in a number of circuits. It was litigated in the 10th Circuit in a case called Planned Parenthood Association of Utah versus Herbert. And the 10th Circuit found, as the other circuits have, that these videos were not, in fact, associated with Planned Parenthood, the false videos that surfaced. And interestingly, the court on rehearing, which Judge Gorsuch sought, characterized his dissenting opinion as, quote, mischaracterization of this litigation and the panel opinion at several turns. Here again, we see Judge Gorsuch going out of his way to rule in a fashion that he sees as indeed necessary to sustain his broad views of religious claims. I'm trying to give an overview of Judge Gorsuch's opinions in a number of different areas. And I'm mystified by how he would reach the conclusions he's reached when we're talking about discrimination laws. Here's one that is very revealing. AFX Rel Christina B. versus Espanola Public School, where a student was found not to be able to sue for violation of the Americans with Disabilities Act because she had earlier settled a suit for violations of another act, the so-called IDEA Act. Well, she has a right under both laws. She would have obviously raised distinctly different claims, and his view was that she should not be in court. This closing of the courts is very, it must be taken seriously, because if you can't get into court in the first place, particularly if you're a member of a minority group or for the moment find yourself in the minority on a particular issue, then you are out of court before you're in court. You've lost before you cross the threshold. I can't imagine what Judge Gorsuch was saying when he didn't allow a student to continue when she had, in frustration, left her school because of violations of her rights disability rights. That frustration, as far as he was concerned, closed the courthouse door to her. Why would we want to interpret discrimination laws in a fashion that you can't even get into court to make your case? A particularly cruel case, Compass Environmental versus OSHRC, involved a holding where Gorsuch wrote the opinion, as I believe. I'm sorry, he wrote the dissent. Involved a worker who was electrocuted, and died as a result. The corporation had trained its workers. This worker happened to come to work to be hired after the training had taken place. Therefore, was not aware of all of the safeguards. The Occupational Safety and Health Review Commission found that the electrocution of this worker could have been avoided if the corporation, Compass Environmental, had provided the necessary training. So it cited Compass and it fined Compass. Gorsuch dissented. He found that the company had not violated the law. The company hadn't provided the records of training. The man was electrocuted. And it's very instructive what he said. Administrative agencies enjoy remarkable powers in our legal order. Their interpretations of ambiguous statutes control even when everyone thinks Congress really meant something else. He didn't like the administrative ruling, and so he dissented and would have ruled against the family of the man who was electrocuted. That is not a man I want on the Supreme Court. That is not a man who knows how to interpret broadly the discrimination statutes, which have always been interpreted broadly by the federal courts. That is not a man who should sit on the Supreme Court of the United States. Now, my good friend, Representative Jackson Lee, who is co-anchoring this hour with me, now would like to say a few words.
I thank the gentlelady for, again, articulating really egregious both opinions and judicial approach and temperament of Judge Gorsuch. And I will conclude my remarks with a focus on the issues of women's rights and as well some cases dealing with immigration. Immigration, Mr. Speaker, is a crucial issue that we are addressing now. In fact, I will cite an incident that happened in our district or my district or in my community just a few days ago, which means as we proceed, there's maybe a number of cases coming to the federal courts and the district court, because I think, as my colleague has indicated, both of us have indicated, that the courts are for petitioning. That is what the courts are for, and it seems that Judge Gorsuch wants to slam the door, and this is a, how should I say it, a metaphor. It is not a precise comments by the judge, but annoyed that people have to come and use the courts. As he's indicated, minorities and women and others want to use the court for their social agenda. And for fear of being redundant, I feel moved. My passion is so strong because, Judge Gorsuch, have you walked at any moment in your life in my shoes as a woman and as a minority? Have you walked in the shoes of the little children who made the of the plaintiffs of Brown versus Topeka? Were you in any way discriminated against with respect to education? Have you ever been a victim of stop and frisk? Have you ever been incarcerated for something you did not do? Have you ever been a woman who's been subjected to sexual harassment or discrimination? Do you understand the purpose of Title VII? Do you understand the value of affirmative action, both in policy and law? And just a few weeks ago, we got a effective and important decision on affirmative action out of this Supreme Court, and a 4-4 in a court that is 4-4. I don't think that's the case. And I just, again, want to take this as I cite these cases. I just want to, again, cite Amanda Bronstad, that some of his decisions may have favored one or two plaintiffs. I'm not going to deny that. But Gorsuch's careful judicial reasoning and parsing of statutory language has more than often led him to side with the defense. That is not the role of a Supreme Court justice. It is not to side with anyone. It is to have the view on the basis of the appeal within the context of precedents and others, how a decision should be rendered. So these are Judge Gorsuch's decisions. In Strickland versus UPS, Gorsuch dissented from a ruling giving a female UPS driver a chance to prove sex discrimination, arguing that the plaintiff had not provided evidence that she was treated less favorably than her male colleagues, even though in the documents submitted in the lower court, her co-workers testified and gave written testimony detailing the level of mistreatment they witnessed her receiving while employed by UPS. In Wang versus Kansas State University, involved a professor employed by Kansas State University who was diagnosed with cancer and after treatments requested an extension of her disability, another woman, due to a flu outbreak on campus which could potentially compromise her health. And Judge Gorsuch talked about showing up is an essential job function, and that the Rehabilitation Act should not be used as a safety net for employees who cannot work. I think her request was an extension, not a forever. Two women, among others, that he found no reason to be supportive of. He could find no legal precedent, nothing that would give him the ability to make a decision that was within the law and humane, even though he was in the dissent. And then in Planned Parenthood Association of Utah versus Hebert, the governor of that state, again, he dissented against the court's majority impacting women's health to decline a full court review of the case. The court's majority decision to decline a full court review of the case in which Governor Hebert of Utah stripped federal funding away from Planned Parenthood. Neither party requested a full court review. However, Judge Gorsuch desired to deviate from court practices and norms to signal his favor for Governor Hebert's decision. Other women, he continues to show hostility toward women's rights and his willingness to overlook institutions that discriminate against women. His record indicates that. Let me finish with this comment on immigration. And if I might, Mr. Speaker, how much time remaining?
2 minutes remaining.
Well, let me finish quickly and yield to my colleague from the District of Columbia if she wants to close. Let me indicate an immigration case. 1 minute remaining. 2 minutes remaining. 1 minute remaining. 2 minutes 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 rem and he voted to affirm the district court's granting of summary judgment, which blocked a Title VII national origin discrimination case from going to trial, despite evidence of animus, unlawful reverberification, and document abuse by the employer. So I close. There's so much to say about Judge Gorsuch. There's so much to say about the stance that is being taken by colleagues who are not being political, who are not talking about the 2016 election, who are simply talking about the courthouse door being slammed in the face of the most vulnerable. I believe that this judge should not ascend to the United States Supreme Court. With that, I yield back to the gentlelady.
I thank my good friend for helping us document why we believe this is not the time for this justice to be on the Supreme Court. We recognize that it is not the House of Representatives that decides this matter, but the Congressional Black Caucus represents 17 million Americans who will be deeply affected by who sits on this court. I appreciate that we've had this full hour to express our views, and I move that the House do now adjourn.
The gentlelady yields back. The question is on the motion to adjourn. Those in favor say aye. Aye. Those opposed, no. The ayes have it. The motion is adopted. Accordingly, the House stands adjourned until 10 a.m. tomorrow for morning hour debate.